This meeting is being recorded.
Okay, hi, Kate Floss, citizen lawyer, citizen going to the court person. Today I'm calling in a person from a man called David Higgs, who lives over there in America, but he had a very interesting video to play, and David Higgs has agreed to come and talk with us in New Zealand today about our case where we've taken the Prime Minister to the court, and then they have said to me that I wasn't allowed to be a subject, that I had to be a citizen, and I wanted to stand in my subject law, in the British common law as a subject. And so I was listening to David Higgs, and he had said this very interesting thing about a test of law, and that the judges will see the law and there will be a test. I don't quite understand everything that he said, but I'm going to play his video, and then I'm going to tell him a little bit about the judge's ruling in our case from the Team Oreo. We have a team called Team Oreo, from the Oreo team in our case. And then hopefully David Higgs is going to be kind enough to come back and let us know how we can refine what we want to say into a reasonable argument. So I'll play David Higgs here first. Have a listen.
That's great. Everybody wants to use equity, but that's an arbitrary set of legal terms and legal circumstances that the judge can just make presumption to overreach the law, and in the lack of, again, evidence or lack of law that supports your right to use the law as opposed to equity. So he has that whole field, and then he can continue to bounce around it, but never create an error because you never brought the test in order to distinguish the law that he has to first deal with or affect before he can now move in the matter. When you bring in the idea of test, I want the test in which made you determine that I'm under that jurisdiction. So now I have an appealable offense or appealable means in which to go to court, because without law, you don't have an appeal. So now
right, so I'm going to stop that right there, and then I'm going to show, so I'll stop that share right there, and then I'm going to show David the law that the judge said, and then I'll just explain a little bit on that law. So this, let me see, where is he now? Justice Brown. All right, so I will just show David this little thing here, that I wanted to show him two things, just so he can get the background of our case. So he's not, he's a very intelligent person and's got a lot more experience than what I've got. And so he'll be able to tell us a lot more than what I can, but he'll only be able to tell us that if he knows what I'm talking about clearly. So one of the laws that we were using under the subject, as a subject under the Queen, was this common law here. Part of it was this one here, that it says that the right be done to every person. Now the key here is person, and saving through the same our Lord the King is regality and prerogative. And that the good justice, that good justice be done 2 times even. So 2 times even the right done to every person, as to saving to the same our Lord the King in his regality and prerogative. So our right is doubly more important even than the King, even than the Lord's spiritual, Lord's temporal. Our law is more important. But the key point here, now I don't want to get into this argument of what a person is, but I'm just using our common law. And the key point here is that they've used the word person, okay? Now, in the 1688, this is called the I'll use the Bill of Rights, but it's called the Will of Mary. I'll go to the Will of Mary. So in the 1688 Will of Mary, there's a right here that is called that, oh, hang on, I'll have to get it for you. here, that it is the right of the subject to petition the king, and all commitments and all prosecutions for such petitioning are illegal. Now, this will and Mary gives us the right. They said that we had the right to go directly to the court whenever any of our rights have been violated. We've got the right to go directly to the court and call the ministers in and ask for a declaration, and that's what I did. I called in the Prime Minister of New Zealand and I said that they had not been upholding my rights. And what they did is they turned around. It's neither here nor there why I called the Prime Minister in, but in this will and Mary, it says that the subject, any subject can do that. And so we can go to the court, we can get the declaration, and it's only a declaration, there's no prosecution. It just says that the government made a law that is repugnant to my right. And it says that it's given you a declaration to clarify that this is your right. And you can then take that to the government and say you've violated my right. And that's supposed to be, it says that there will be no commitments, meaning you should not have to pay for that. And there'll be no prosecution because you haven't committed a crime. You've only gone to the court and said the government has been acting repugnantly to my right and asked for a declaration. So there's no crime here. And so that's why you're not allowed to prosecute. So anyway, my case got turned down, okay? And when my case got turned down, and then it was turned down on this law called a Mannix law. The Mannix law is that the government is a corporation and that you as a citizen are a part of that corporation. You're also a corporation under them, some kind of thing that you would know more about than me, David Higgs. But anyway, the government, they said, so a corporation must be represented by a solicitor. And so they said, since you're not a solicitor, you're not allowed, our corporation of the government, the Prime Minister, doesn't have to answer to you because you're not a solicitor, you're below, you're a lowly peasant. You're a lowly peasant and we don't hear you, we don't want to talk to you. But I appealed that to the appeals court and the appeals court ordered the Prime Minister to come to the court and meet with me. So there's a direct order from the appeals court. And the appeals court said to the Prime Minister, if you don't come to meet with this case, we're going to carry on this case without you, and this person is going to be heard in this court. And we won't inform you of any of the goings on in this court if you decide not to come. So their Crown Counsel sent a letter back and they said, we will be attending. But then they hit me with a whole pile of fees, which amounted to around about $14,000. So I threw up my subject law there, that's the right to petition to the king, which goes through our Supreme Court. So you don't actually petition directly to the king or the queen. You petition to the Supreme Courts, into the higher courts, not the subordinate administrative courts. You petition to the higher courts. And if it's found that if you keep using your will and Mary and your subject right, if you keep using that, if the courts make a ruling that's repugnant to that, you're then allowed to go to Westminster and petition directly in the King's Bench. So I'm currently in the Supreme Court. Now, I said that so when I got in that appeals court, they said, yep, they've all got to come to meet with you and they've got to come to discuss the issues that you want to discuss with them. They hit me with the fees and then I prosecuted the appeals court. So the whole thing changed. And I said, I applied for a fee waiver and they turned me down based on two things. First of all, they said that you can only petition if you're a group. You're not allowed to petition as a person, but as you just saw there, it says the word person, that one person can come. And the will and Mary says that one person can come. So they said, according to a law in 2016, in that law, it says that you have to be a part of a group, or you have to be a significant in public interest, is what they said. And they said, since you're only one person, we don't allow you to get a fee waiver of the $10,000. So this law here that I'll just show you here, this one is significant here, David, is called the Declaratory Judgment Act 1908, and this is matched to the Will and Mary, that it is our right. We can even take the Queen to court if they make laws repugnant. So that's part of the common America. Because in America you have to be in the group, but in our common law countries we are permitted to go directly to the Supreme Court and call the Prime Minister into the Supreme Court, and even call the Queen into the Supreme Court. We're permitted to do that. So it's a little bit different from America. In this Declaratory Judgment Act, I hope you can see it, but it says there, it says that no action or proceeding in the High Court will be open to any objection that is merely on the ground that it is merely seeking a declaratory judgment or order is sought thereby, and the said court may make binding declarations of right. Now, you were talking a lot about equity, but I'm talking about right. And when we get a declaration of right, it's out of the corporation. It's nothing to do with the corporation. It is just our godly right that we can stand in. And so if they make a law that's repugnant to our right, we are permitted. But here it says here 3 times, where any person desires to do any act in its validity or legality, which depends on the construction or validity of a statute or regulation made by the Governor General or local authority, or any deed, any will, any title. It says the word here, person, then it says here the word person, and then it says here the word person. So it says the word person 3 times. And this was done in 1908, and it matched to the Declaratory Judgment Act, all right? Now, when, so what had happened is that way back in the 1700s, when now I'm going all over the place here, David, but you'll see where I'm coming from. When all the people were shipped out on the ships from Germany, the German Protestants and the Huguenots were sent out to America and New Zealand and Australia on the white slave ships. When they were all sent out, they were all given a parliamentary act was made in England for them. And they weren't made citizens, they weren't made nationals, but they were made subjects. And under the subject law, it didn't matter which country that they arrived in, if the government of that country made any laws that was repugnant to their right, they were permitted to petition directly to the Supreme Court and petition directly to the Queen as a subject. And so that's why it was very important for them. Now, those parliamentary acts were done, so I can show you here, because it's those parliamentary acts were, hang on, I'll just drag it up for you. Those parliamentary acts were done for America, New Zealand. There was a lot done in America, a great lot done in America. And I believe that those, oh, ouch. I believe that, oh, I just went over my toe with my chair. I believe that those acts were mostly for people that are living in Pennsylvania, and they utilize that today. So this was a citizenship. Here, you see where people got naturalized and citizenship, but there's one down here starting from 1844. See if I can find it here. Private Acts of Parliament. So these were private acts of Parliament done in 1844. And in these ones, we didn't get citizenship. We were made subjects, which gave us the power to take any parliamentary person directly to the Supreme Court. No going to the police, no going past anyone. You can serve them directly, and I did that. I served the Prime Minister directly. I never went through the police. I never went through the court. I went through the court and they gave me service papers and I served them directly in my subject status. So these here were called Private Acts of Parliament, and they were done on a parchment roll, on the Parliament rolls. And yours in America, this was called the Foreign Protestants Living in America, and yours in America got from 1740 through to 1772. Yours still stand to this day. And then, so there's quite a bit on there, the Huguenot Society. And so that's kind of where I'm coming from, that I went to the court as a citizen and as a singular person. Now, I'll get to the judge now. Now I'm going to get to the judge, David, and this is where I'm going to be calling you in to help me out with your, that you were talking about. What is the test? So I'll stop the share on that and I'll go to this judge's ruling. So this judge here, he's turned around right at the bottom here. Don't worry about all of that. At the bottom here, he has refined it. So he's turned around, and so S3 of the Declaratory Judgment Acts says a person 3 times. A person can call them to the court, and also the subject status of the Will and Mary says that no commitments and no prosecutions will be allowed to any subject that wants to petition to the court on a point of law that they think that the government should not be using against them. And it says that a person, now they turned down my fee waiver and they said under the regulation 5.4 in 2016, you must be a group and you must be a significant, in regards, your petition must be in regards to a significant portion of society. And so they said you're not allowed to get the fee waiver because you're not part of a group. And so they've tried to put me into the United Nations human rights, and in all the human rights, you have to be a group. But I'm not in any of their groups because I have to be a homosexual, or I have to be an ethnic person, or I have to be an immigrant person, or I have to be of Indigenous status, or I have to be in certain women's groups, or I have to be in a workers group. They say that I have to be in a group, but I'm saying I'm standing in my godly status, in my own right, in my own subject person, in my own self. So he said that you are regulated by 5.4 regardless of the jurisdictional route that you take. Then I said under my 1844 Act of Parliament, of the German Settlers Act of Parliament, I'm standing in my subject status. I want to be a subject because as a subject, it says I don't have to pay if I want to petition about a point of law. But he said, while Ms. Sextus may bring proceedings in the New Zealand court like any other New Zealand citizen, she's not exempt from the application of fees. So there's 2 points of law here that I'm going to be asking you about, David. I think I'll go to the hot potato first. That is very extremely relevant to your video where you said that what is the test? How does he get to name me a citizen when I've been going to the court in my subject status, and he keeps coming back to me saying to me, you're a citizen and we don't allow you to be a subject anymore because we've made you a citizen now. So, are you with me on all of that, David? Do you have any questions before you tell me your answers?
Regards to what you said, and that's amazing work on your behalf, by the way, and you know, quite the due diligence to get that far and get acknowledgement that the Prime Minister must attend the court hearing. First of all, I'll correct you on the fact that the territory that I deal within in the courts is Canada, so it's not America or the US.
Oh,
okay.
Really
Yeah, no problem, because but that means we're a lot closer in the Commonwealth concept than we were with the US concept, even though all of us are under free and common sockage and under English law. So there's nobody that's can be moved away from that, because that's what we've all agreed to initially, to which that sets a precedent for every subsequent law, whether in US, New Zealand, Canada, whatever be the case. Now, what you're discussing is something I wouldn't delve into. I wouldn't even deal with the governments at all. So, you know, I won't get into that nuance, because this whole thing is that in 1688 Bill of Rights, we were no longer subject. And that was the move from despotic monarchy into a constitutional monarchy, which then gave us really at that point our right to leave the settlement, or leave what was before the feudal land tenure system that went into the free and common sockage system. Now, when we talk about tests, you just want to start talking about tests here. Tests are those formulations that the courts you search for based on the matter that you're trying to discern, where the courts have said certain criteria that has to be met in order to define whether you are a subject or a citizen. That is, I don't know what that test is, but there has to be one, because it cannot be announcing to you that you want to, you know, you are a citizen, and you cannot now come in as a subject. So there's a commingling going on. And what I mean by that, the law, you know, is people get caught up in the name game and all those certain things and legal personages and so forth, but you can only come into English law through a legal person. The issue is what status you are that you're using that defines this legal person. Okay, so for instance, you've got the concept of a trust prior to government, prior to constitution. Then you've got the constructs of the trust under government, and those are two separate issues, whereby the one prior to government that we're looking at is be through the common law, which is English common law. And maybe we should get some dissection there. Is that, I mean, there's common law in New Zealand, Americas, you know, in Canada, and then there's the English common law. So when you talk common law, when I speak common law, I'm speaking the English common law, which is your birthright, to which was solidified in the 1700 Act of Settlements. The English law is your birthright. So everything is under that you can use, but how you use it is dependent upon the status that you're coming in as. So what you're speaking about is citizenship and subject, and you're dealing with issues that you have against the government. Well, the government means that you've made an agreement to then come in under the third, and this is, hopefully I don't get too convoluted here in what I'm going to say, but because I know I'm going to say new words, and I know that it won't be something that it's on the tip of most people's tongues, but you've come in under the third level of use to land under a trust for sale scheme. Now, that is identified through the Law of Property Act 1925. So what we have done is we've have bought rights to the possession of things under the trust for sale, but not ownership of things. Okay, so we're exercising rights. And as a citizen, that's all you've ever purchased in your life, is you purchase a right to use the land, subject to fee simple and leaseholds. Okay, but that's what you've done. And there's a status prior to that, because English law is a hierarchical system of land holding, is what it is. In fact, English law does not register, a real human. It doesn't deal essentially with people. It deals with land and those interests annexed to land, to which then if you make an agreement, inadvertently or voluntarily, then you become subject to that agreement, to which then now you become, they administrate that agreement over you, because it's over the property that you're using, or the right to that property, that then brings in a law. It's not against you, it's what the property is holding, to which then, based on your status, determines what type of property you can hold, or a state or a land. So now there's 3 levels there. So as you see, now I'm getting into something that I know that you're not familiar with, because you're talking against citizen and subject.
No, but I'm understand. I'm hearing you, and if you talk not too fast, and I'm understanding exactly what you're saying. So
great.
And I'm understanding. So it's not too hard for me just yet.
Okay.
But it might. But right now,
because the mannerism that you're dealing with is not what I would be dealing with, because that's not where my true right is. Or put it this way, we all have absolute rights. No one can take those away from us. What overreaches our absolute rights is the discernment of an agreement. And because you're a citizen or a subject, that means it's a certain agreement that you're making pertaining to a certain subject matter. And that subject matter is dependent on your status. So just to get to back to your point, yes, there is going to be a test. What then facilitates the criteria of one being a subject and there's one being a citizen? There's going to be, up to 3 different points that's got to be hit in order for them, and they're doing it in their mind. They don't need to be, they're not announcing to court, but if you go to appeal courts and Supreme Courts, you will find that it's already been debated and it's already been established how that has been identified. So we have here called Can Lee, and you'll probably have some sort of Zealand Lee or something of that nature, where you can access case law in your area. And there's going to be a test. Now, once you identify the test, then that is the only thing that you would go to the civil procedure. So, what the Crown Proceeding Act, that's what it's here defined here in where I'm at. But it could be just, something else. But it's some proceeding you have against the Crown, which you would bring in the Attorney General to petition or application. It's again dependent upon the structure that's set up for the Crown, for your proceeding against the Crown, that you would petition or apply to the court to get a jurisdiction challenge on whether, based on the rules or based on the test that's been identified, whether you can be identified as a subject or a citizen. So that's what you would have to go for next steps. Okay. But okay.
Because I just in 1840 in New Zealand, right, a treaty was signed with the New Zealand natives, and on that treaty, which is a bit different from Canada, on that treaty, they said that the British law would, Her Majesty, the Queen Victoria, would bring in the law to protect her subjects and the natives. And the British law was actually, the Queen's law was actually brought into New Zealand to be able to prosecute foreign people that were in New Zealand that were committing crimes against other British subjects and people that were in New Zealand. and the New Zealand natives weren't able to control it. So they were tar and feathering people and hanging people and all of this under this common law that was not a written common law, just they made it up as they went along. They held these citizen courts and they made decisions and they hung people and all of this kind of things. They took their property from them. And so when the treaty was agreed to, it was agreed that Her Majesty Queen Victoria would bring in her laws to protect the Anglo people. Now, as soon as that happened, there were many of these parliamentary acts, and I got a parliamentary, my ship, they set up, there were 3 ships in England of 5,000 people on each that came from Scotland, Ireland, and England. And then there was also another ship that came from Germany, a ship full of Protestants from Germany called the St. Pauli. And each of the peoples on those ships had bought shares in a company called the New Zealand Company at £300, £300 a share, I think it was. So there was criteria to go on those ships, but the main thing about all of this criteria was for them to go and produce the labour. My ancestors went as the labourers to build the country. The criteria that the chiefs in New Zealand were allowed to have these people come as labourers was that they would be forever protected under their subject status under the 1688 Will and Mary of their rights. And the people on the St. Pauli, which had 5 brothers, of which one of them is my great-great-great-grandfather, and they got a letter from directly with Queen Victoria, nothing to do with the government, nothing to do with the natives, but directly in a parliamentary act in Westminster, were made subjects of Her Majesty under the protections, and the list of names of those people was on that document. That's a forever document and it can't be changed. Well, that was done in 1844. And the chiefs in New Zealand, the paramount chief called Chief Nene, he was on 3 coins with King George V and then Queen Victoria and then I think it was King William, might have been King William. Anyway, 2 kings and 1 Queen Victoria. So he was a paramount chief, or practically a king. So he was the one that had the power to issue laws in the country for the immigrants that were coming in. So he had to have signed off on it. And then the actual British nationality didn't come in until 1869, British nationality. So it went in that group. It went the treaty, then it went the subject status to certain people, which was a forever document that we would forever be permitted to use those laws if we wished to, and call any official into the court at any time that we wish, if it is in regard to a point of law. The British nationality came in 1869, which was 30 years later, and then the New Zealand citizenship, and we lost nationality, and we got citizenship in 1949. So now in New Zealand, they've brought in the Human Rights Act, and they've said that we all have to go under that. But I'm saying I don't want to go under that because I'm not in any of their groups. And so I don't get basically any rights in their act because I'm not Indigenous, not homosexual, I'm not. And so they said, you're not allowed to come to the court because you don't have a group that's within that act, that's defined within that act. So I said, well, I don't need to be defined by that Human Rights Act because I'm coming in under my 1688 Bill of Rights, which is in New Zealand. It's also in New Zealand law, and it comes from England as well. We've got a double, and that says I can come in by myself. So what I'm saying to the court is that I want to rewind I don't want to be in their citizenship. I can be a citizen and I can be a subject. And I don't have to be a citizen and a human, because I don't want to be a human. I want to be a subject. So I got given that document passed down from my ancestors, right? So they should be still beholden to that document that was given to my ancestors that said these people in a direct covenant with Queen Victoria have claimed their subject status. So that was the reason why they came out from Germany. The promise, because in Germany, the Protestants, as you know from Martin Luther, not Martin Luther King, but Martin Luther, that was fighting the Catholics and the Islamists and the Jews and didn't want to be under their laws. And he started the protest ants. And then they were killing them, chopping off their head, chopping out their tongues, slitting open their stomachs and putting out their entrails. So a lot of the German Protestants fled the country because they wanted to be protected under their subject status as a Protestant, not because they were not able to fit under the Islamist laws. They weren't able to fit under the Catholic laws or fit under the Jewish laws. So they made their own Protestant in 1688, their own Protestant protections. And I want to stand in there. That's where I want to stand. I don't want to stand. I think I can stand subject and citizen, or I can stand in citizen and human rights with the United Nations. I think I can choose. Do you think I?
Well, no, in some circumstances that won't essentially work, because we're talking commingling those rights that are granted to, say, a subject under the common law, the English law, and then those are granted to a citizen, which are granted those prohibitions, limitations under a government entity. So what is happening, I can see, is that they're presuming that you are a citizen at all time, because what is going on, if you're unable to identify that you are not, and you are a subject, then they have to automatically throw you into the cause of being a citizen, because you haven't yet identified what it is that makes you not a citizen and rather a subject. So you're not able to come in with both, with your feet on either side of the track. You're either in equity or you're in the law. So how I see it is that if you got, the things here that identify citizenship is residence. And the next thing is, where do you work? If you identify with those two, then that's going to pass the test of that you're a citizen. A subject would be, which I haven't looked into what the test would be, what would be a subject as opposed to a citizen. And again, that would be argued or debated already within your own Supreme Court case law. That will be there somewhere along the line, and you just have to go through that site and type words like subject status, and
here's New Zealand law. Sorry to interrupt, but here's the New Zealand law, and it's in New Zealand legislation, and it's in the Cabinet Manual. They put two laws into the Cabinet Manual that Parliament have to follow in order to govern. The first one was the 1688 Bill of Rights.
Right.
And the second one was the United Nations 1990 Human Rights. Under the human rights, you're not allowed to take parliamentarians to the court. And it's also got a justified limitations that the parliamentarians can override any of the rights within it. But at the bottom, it's got a section called S28. And in S28, it says the ancient rights are unaffected by it.
Right.
So I'm coming in under S28, and under this New Zealand Bill of Rights here, this one says that I can take them to the court as a subject, because it says here, these are the subject's rights, because it says here that the majesty who it has pleased Almighty God to make the glorious instrument, only the instrument, not the ruler, only the instrument, to make sure that our rights are upheld. So that's what they've got to do. And so these are for vindicating and asserting all of our ancient rights and our ancient liberties. So they made a law in that 1990 human rights that New Zealand people will be bound to any international instrument. And I prosecuted that because I said, I don't want to be bound. I want to know what the instrument is before you make me bound to it. So that is what I have taken to the court. And so, because it says here that we have the right, that it is the right of subjects to petition the king, that you do through the Supreme Court, and all commitments and prosecutions for such petitioning are illegal. And then according, this is New Zealand law, this is right in the New Zealand law, then it says here that there will be frequent parliaments for the redress of all of our grievances and amending and strengthening and preserving our laws. And it says that no declarations or judgments or proceedings to the prejudice of the people shall be brought into consequence or controversy. And it says that the means, if they do that against us, if they do make anything that's repugnant, the means for getting the redress is, or the remedy, the means for getting the remedy is by going through the Prince and Princess of Orange, or by going through the Supreme Court. And then we can go to the liberties to be allowed, and we can ask for a declaration. And this is where we ask for a declaration, and then all officers and all ministers shall serve their majesties, which is us, and their successors for all time to come. So that I've gone to the court and asked for a declaration to affirm that these rights here exist, that I am a subject. I've asked them for a declaration to say, yes, you are a subject, and yes, these laws are, this is a remedy that you can use if you wish to in the courts, because it's in the legislation. And so, but they've turned around and said, you're not a subject. But it's in their law that I can be a subject. So they just said, well, you're a citizen, and as a citizen, you have to follow this other set of laws that we've moved you. We've moved you out of subject, we've moved you. And what they're trying to put us under is the Maori customary law. That what they're trying, they have now instituted the native customary law into the courts of New Zealand, and they're trying to force us to go under those laws. And their native king has signed a pact. They just translated the Islamic Quran into the New Zealand Maori language, and they performed an Islamic ceremony on the most important, they call them the marae, which is where the king, the native kings and the native chiefs go to frame their own laws. They instituted Islamic law into that. It's called a native parliamentary court area, just to put it simply for you. And so when they did that, because we fought for thousands of years to get out from under these religious laws, and I didn't want to be placed under those laws. So that's why I've gone to the court. We've gone to the court to claim our subject status, so that even if they hand the country back to the natives, even if they bring in the native laws, I'm saying, hey, your ancient chief signed a deal with our ancient queen that said that we would stand in our subject status forever, and we're not under your laws. You can't force me to be under your laws as a citizen, because as a citizen of the country, if they change the law of the country to be native Maori law under the native Maori language, if they do that, where do we stand? We've lost, or we are bound as a citizen under their law if they decide that that's their law. So I'm saying I don't want to be bound to that. I want to stay in my subject status.
Well, you know what? I think that you are already on the right track in order to get this matter heard and determined. Let's just go to the law of domicile. Law of domicile is involuntary, as you may know already. So, and it's split into 3 categories, which is by origin or birth or by choice.
Origin.
So everyone.
Wait, slow down because I have to write it. So your
Okay.
origin, or is that your birthplace?
Yeah, well, origin would be, the place where you would say that, your parents are citizens of or subjects of, okay? And then your birthplace, so let's say if you were traveling to another country and you were born there, then that would be, the place of birth that happened.
Right.
But your origin would be where your parents originated from. And then choice is, and choice or choice. So everything's or, it's not and, it's or. So, or choice. So that means you have a choice of what your domicile is. So,
or the domicile, right? Oh,
right. So you're
excellent word. Yeah, I'll put that in there. That is a perfect word. That it's my choice which domicile. Let me write that. Very important. So it's my choice. That's a perfect sentence. That's so clear, and that. It's just one sentence, but it's huge, that sentence that you've just said.
Right.
So it's my choice, which domicile, what does domicile mean?
Well, domicile would be, also considered with residence as well. So, I mean, again, it's all dependent upon what status you are to define what that means particularly.
That could be a domicile of right, though, couldn't it? It doesn't have to be land. It can be a domicile of right. Can it be or not? Or does it have to be land?
Well, we have to then maybe consider and answer that question by the fact, what does English law deal with? And they only affect land and rights to annex to land. So, rules of action against land and those rights annexed to land, that's what they deal with. They don't deal with people. So it would be, the domicile would be pertinent to whatever interest you have in land subject to your status in English law. So you're probably going to have to hear this a few times, and I'm not trying to make it convoluted, but
hang on. When the German settlers went to New Zealand, before they were allowed to step off the ship, they were given, every man, woman, and child on that ship was given an acreage of land. And before they even stepped foot off the ship, that right, that subject right, was annexed to them. So the judge just said that I've put in this annex. He said, I'll read it for you. So, because I'm not really on the land thing, but he said she refers to aspects of her heritage annexing an ordinance of 16th of July 1840 concerning the naturalization of the German settlers. So what they did, basically, that's exactly what they did. Before we were allowed, my ancestors, before they were allowed off the ship, they attached land to them. And when they attached land, and then through that land attachment, they then attached their subject right. so that the person and the land and the godly right were all attached together in one package. Because in some people that have subject status are not, by law, they're not permitted to buy native title land, pure title land. They're not allowed to. And so anyone that was permitted into the lands of New Zealand had to be, anyone that was permitted to actually live there and settle there and stay there had to be of subject status to stop them buying the pure title land from the natives. If they bought the pure title land, the Queen would come in and snatch it up because they were a subject. So under the subject status, when any person that has been, that's why some people want to get out of the subject status. But once you've got your subject status, you're not permitted to buy pure title land. And if you do buy pure title land, as a lot of people did way back then, the Majesty would scoop it off you, and then she would talk with the natives and she would say to them, do you want to sell this land or not? And if they said yes, then she would buy that land from them. She would buy it. She would keep the pure title entity, or that pure title, she would keep it. Then she would give a land grant in a paper title to the subjects who wished to purchase it. And so before anyone was allowed to, but there's two agreements here, because before anyone was allowed to step off the ship, they got given that land. On the other hand, so that land, although it sat, the natives sold it, and although it sat in the basket of the Queen, right, it always belonged to them forever. And if they ever wanted to take that land back, they would say to the Queen, I want that land back. But because of the 1688 Bill of Rights, forfeiture of person without conviction is illegal, she couldn't just take that land back. She had to wait until those people that were on that land with the paper title were willing to sell. Those people were willing to sell, then that land would go back to the Queen, and then the Queen would talk with the natives again, and she would hand that pure title back to them if they could prove their lineage back to the chief of that time. So the land belonged to the natives, but we were protected in our right of person, our right of godliness, to our natural laws of protections. So when the people came on that ship, that's how they got connected, that they were given an acreage of land, and they had the rights, subject rights, which were annexed to them through the land, and that at that time they were allowed to step on shore. Are you with me there? Am I right there?
Well, I could see how it is all, you know, connected together, because the agreement with the natives is a completely different agreement than the subjects, and that the fact is, again, that status whereby Her Majesty, now that's Her Majesty, the real person sitting on the throne, as opposed to the legal personage, the crown, holds the land. How was it said in Mercer versus the Attorney General, 1881? Let me just think of what the actual statement is. It says, the sovereign is chosen by society to hold the land for the people as fideicommissium. And fideicommissium is just more or less another transfer, or another word, a diluted word for trustee. So she's trustee. So that is correct. And that's the common law. That's your dominion right. So there's a dominion right that you have before Her Majesty, which through operation of law transfers your dominion interest into Her Majesty, to which is held. from there, it runs into an undivided share, and I'm sure there's, of course, divided shares for those of the agreements and treaties with the natives, as there is for the subjects. And that undivided share is where you are allowed to pick through via purchase under a trust for sale is what you're doing. Okay, so what it sounds like to me is, again, there's rights of the person and there's rights of things. Now, if you went to Blackstone's commentaries, you get it easily online. It actually lays out the rights of kings. That might be a great one for you to read, and the rights of parliament and the rights, those kind of things, so that you have a better perspective of how everyone's playing within this system of English land law. So again, your focus then is now that you have a choice, so you have a choice to be subject, then is to seek the test that has already been debated, whereby you pass that test to wherever the requirements are, then you are subject. To which, again, you have a choice already, so you can, no matter what, make that choice to be subject. They can't take away the choice from you, as same as they can't refine, or what's the word I'm looking for, when they not revise statute, but they, what's the name? Can't believe I'm on the tip of my tongue, but they can't change the laws that are structured for the subject, because they have no interest in that. They have interest in their citizens. Okay, so like you said, that's true. The subject remains as is and within its laws, and the citizen remains as it is within its laws.
Oh, wait. That's
okay.
a good one. So the subject remains, oh, very good, very good. The subject remains as is within
their laws. Yep.
And can I say, and the citizen remains citizen within its laws?
That's correct.
Oh, good. All right. So, and the citizen, oh, that's beautiful. And the citizen remains as is. Oh, that's going to get them thinking, and that within its laws. I mean, you can't dispute that. Yes, have a listen. This is so cool. So it's my choice which domicile.
Yeah.
Can I put which domicile of right?
Domicile of right. Well, let me see how that would play out. It's your choice already says it's the right. See what I'm saying? You're already saying it already by saying you have a choice. That's already instilled in you as having that right to do so, to choose your domicile. So I think that may be redundant to say it that way, just because I
didn't get the complete sentence. I've got my choice which domicile I wish to, and then it's not finished. What's the end of that sentence?
Well, just it's your choice of what domicile you choose to be subject to, really. So that's what you're.
Yes, it's it's my choice which domicile I choose to be subject to.
Correct. Yes.
It's perfect. It's beautiful. Okay, so let me read that. This is so cool. So the judges said, you're not a subject, you're a citizen. And I'm going to say, it's my choice which domicile I choose to be subject to. The subject remains as is within its laws, and the citizen remains as is within, let me read that again because it's so beautiful, I have to get it right. So it's my choice which domicile I choose to be subject to. The subject remains as is within its laws, and the citizen remains as is within its laws also.
Correct. No.
Right, that is exactly right, because they've got this 1990 human rights, and then they've got this 1688 subject right, and they're not the same thing. Each of them holds a different set of rights, and the rights that I use as a Protestant are stronger for me because it protects me from their Islamic laws chopping off my head and their Jewish laws putting me into the pits and stoning me to death, and the Catholic laws of cutting out my tongue for speaking against them. It protects me against all of that. Was their law doesn't protect me against all of that, really. And so they want us to go under these Noahide laws. And I don't want to be under their Noahide laws because their Noahide laws are not I'm not free. I don't want to be under any of the religious laws in any way, shape, or form. And so as a Protestant, I just only want to stay in my own godly Protestant right in my own self. I don't want to be forced into one of their groups, which that's what they're trying to force me into, one of their groups. And I want to stand in my own power, in me. And so that they've got these two sets of laws that they've brought to the table. The 1990 Bill of Rights, which has got a justified limitations. Then S28, which says our ancient rights are not within there. And then I've got my 1688 subject rights. That's where I want to stand. With the case law, there were two case laws. One of the case laws was that, again, they said, that's why I got thrown out. I got struck out in the first round because they said, you're not a solicitor, you're not an attorney general. So therefore you don't have any right to go to the Supreme Court because you're not, basically they said you're unintelligible and you're not worthy of us. That's what they said, you're not worthy, you're too stupid, you're the village idiot. That's basically what they said to me. And so, but I found a law, the ancient laws from 1831, that said that they put up several cases where they said they couldn't, that person could not speak for themselves into the court because they were not a solicitor in the corporate section, the land section, what you're talking about. But then they said, however, when somebody's using their ancient law, that they are permitted to go to the Supreme Court and they cannot be forbidden from doing that. So it depends. So if you're standing in your citizen law and you're using all their subordinate laws and their Subordinate Human Rights Act and all of those things, then if you're using all of that, then I'm saying that you do need a solicitor and you do need a group. But because you're talking about financial equity and commercial products and all of those kinds of things, and obviously, as you can hear from me, I have no idea what they're talking about. But I'm saying when you're standing in your ancient right, only in your right, that you are allowed to go to the court. So, and the law said that I can go to the court if all I want to talk about is my right. And in my right that I originally took them to the court was that, my right the way I originally took them to court was that New Zealand people, all New Zealand people will be bound to any international instrument. And I'm opposed to that. So I don't want to be bound because I don't want to be they're trying to put us under American law, really. They're trying to say you have to go under the American We Are the People law. And I don't want to go under their American We Are the People law because it has a lot of religious freedoms in it. And the I don't agree with religious freedom because originally there was a religious freedom, and the Protestants that didn't want to be confined to their religious laws had their heads chopped off. So I'm opposed to religious freedom. I want to just be standing in my protections of no cruel and unusual punishments and my right to speak freely about anything that I want to speak about, because the law of nature, you can't tell the lion not to roar. You simply cannot. And you cannot tell people not to speak. So you're not allowed to speak against certain things, certain people, certain events. You're not allowed to speak against them that they say. But under my subject status, it says I can speak anytime I want to, because my subject status says that if you feel good about yourself, then words can't hurt you. So there's like this whole battle going on for me, David, and it's just a new, but it's quite late in the day for me to be asking for advice because it's already in the court and I'm quite overwhelmed, to be honest, and I just have found you. And you're the first person that I'm talking to that when I speak to you, you know exactly what I'm talking about. And you can come back with me with a lot of stuff that I didn't know anything about. And I don't have to explain anything to you. I'm very lucky to have found you. I'm ever so grateful. But I've understood everything that you've said today. I'm very unclear about lands, but I think you managed to put it. So I've got here about that. So I'm saying that I want to remain, no matter what the government does, no matter they put us under this native customary law that they're creating, no matter that they throw the Queen out and make New Zealand a republic, I'm saying I still want to claim my subject right within my citizenship status that they have forced on me. Because I wasn't originally a citizen. Originally, from my great-great-grandparents, from 1844 through the Treaty of Waitangi, and from 1844 all the way through to 1869, my family were not subjects nor nationals of any country. They were only subjects that had been annexed to a piece of land within the country of New Zealand under the native chiefs. So, and then that 1688 Will and Mary is a forever document. That one that I just showed you, because that one there that talks about that we have 2 times the right of the kings is what it says. And then that one there, so I'm saying that their citizenship laws are still beholden to my subject law, which came first, because my subject law came first, not their citizenship law didn't come first. My subject law came first, and I have the documents to show that. So then it does say there, it says first that the Holy Church have all her liberties and franchises, and that all the Lord's spiritual and temporal at this time, so this law was made in 1405, at this time they had not added the commons. This was the time when only the kings and the priests ruled over us. When they made the 1688, they added the commons. That doesn't mean to say that this document doesn't exist, because it went, so the Lord's spiritual and Lord's temporal were moved over into the 1688 commoners' right and law. And then they all went under the power of the subjects who had the power over them. It flipped them from them having the power over us to us having the power over them in regards to right, under God. And then all the cities, boroughs and towns franchised have and enjoy all their liberties and franchises. So this is when they had all their lands and everything, which they have the grant of the king's progenitors, which means the descendants, and the confirmation and grant of our Lord the King, and now is, and that the great charter, which was the charter of the forest, which was repealed, and all the ordinances and statutes made in the time of our Lord the King, and in the time of his progenitors, which means his descendants, if not repealed. So that means if it's not been repealed, then it stands. And they did not repeal the covenant of my family from 1844 to 1869 when they made us nationals, and then in 1949 made us citizens. They didn't repeal that first one. So I'm saying if it's not repealed, then even as a citizen, I can still use it. Not everybody can use it, but I can, because I have the evidence that so it said that all the progenitors of Lord's temporal, Lord's spiritual, and all of them have to firmly and hold and keep and duly execute all the points if it's not been repealed, and that the peace within the realm be holden and kept, so that all the king's liege people, I'm standing to say that I'm the king's liege people. I want to be a liege of the king, and the subjects may from henceforth safely and peaceably come and abide by, according to the laws and usages of the same realm, and that good justice and 2 times even right be done to every person. So I'm saying that my subject right has not been repealed, and so they can't force me into those other rights that they said they want us to be under now. I don't want to be there, David.
No, they can't. The government can't repeal laws that are directly, immediately from the king in relationship to subjects. They have no interest in that, like I've said before. So again, there's no way that they repealed it. What they're doing is running under the presumption that by your choice and by your actions, you've agreed to be a citizen. And because of that, and you've not shown anything to the contrary, they are going with the fact, in order for the law to move, that you have agreed to citizenship and those laws that regulate citizenship. So
right, that is where I need to grab what you're saying, because this is the argument they're going to give. So you're saying, right, I'll just clarify that so I hear it correctly. So you're saying that since I agree to be a citizen, then I therefore agree to all of the laws of being a citizen. Is that right?
Well, you've done by your action, not by any oath or any means such as, signing anything that says I'm a citizen. It's just that way that you conducted your affairs, made your purchases, and done things within their government program, if you will, their government structure. It defines you as under their jurisdiction. And again, that's just only because they don't have evidence that you've ever brought in to prove that you are not a citizen of their government. And again, I mean, at this stage, it's, you can say what you want, but I mean, like you're starting to understand, they can throw whatever they want at you, and until you challenge it, that's going to remain. So they don't have any worries. I would go, like I said, through the civil court, and I would make the claim initially, maybe get that straight as the first predominant question. Do I not have the right of choice for my domicile, which we've already discussed? So we're just saying that again. So so once that's clear, well, then we can move on to the next. So what you're doing is building latches to then move the court in the direction to using law to prove that you have the right to then claim or to become a subject and swear allegiance to Her Majesty in that capacity.
Oh, can you say that again, please? That bit that you just said.
Okay, that you have the right to swear allegiance to Her Majesty as a subject.
Yeah.
Because you have the choice of domicile again, so therefore you have the choice of whatever status you wish to use within English law.
Swear allegiance to Her Majesty.
Yes.
As a subject.
Right. You don't want to mix the crown. The crown is that legal personage that's dealing with the government. You want to deal with Her Majesty directly, that you are swearing allegiance to Her Majesty as your subject, as her subject.
And does that, and is that as a citizen too? So I stay a citizen, right?
Well,
I can be a citizen and a subject, because I don't understand, where I'm not really understanding you is that as a citizen, because those laws, they've got the 1990 Bill of Rights that is available to citizens. It's there and it's in New Zealand law, and they can choose to use it if they want to. But I'm saying that the 1688 is also a law. It's in the Cabinet Manual as a right. And I'm saying that, and that is also as a citizen, but here's the problem. Not every citizen wishes to stand as allegiant to the Queen, because a lot of citizens don't want to be allegiant to the Queen, but that's not my problem. Why is that my problem?
well, it's not. It's. I don't think it's an issue of being a problem. It's everyone has a right of choice to make their free will choice of how they want to interact under English law. So again, it's if you want to deal with anything, you as an individual have an absolute right to. Well, I don't want to go too far because I know you want to deal as a subject, and you're bringing in citizenship and you're bringing in a subject. If they were something that could be transverse back and forth, then there would be no problem. So obviously there's a problem when they said you're still a citizen, which means that you can't be a subject at the same time. So you see, you can't be two of the same thing. You either are a citizen or a subject. You have to make that choice. That's the choice you make.
Okay. So this is very good. This is good talking here. So you're saying that I can't be a citizen and a subject at the same time. And
right.
So that means, and I'm a citizen because of my domicile, because that I live there. So that's what makes me a citizen.
You're agreeing to that, right? Yeah.
To renounce my citizenship, but then I wouldn't be a subject in that country anyway, because I would not then be connected to the land. But so why have they got, how have they got that law in New Zealand? How come people are allowed to use the 1990 Human Rights Act as a citizen, but I'm not allowed to use the 1688 Bill of Rights Act as a subject and citizen?
Because like again, it's
human, but I'm saying I don't want to be human. I want to be subject, not human.
Okay,
so
well then, yeah, I think that what you're doing is, okay, there's three levels. Now I try to explain this to people, how the court see things. The law is first, evidence is second, and opinion is third. So
law first, yeah, and then evidence is second.
And then opinion is third.
Yes, and then opinion, well, the judge only made the opinion, well, in the one where we had the two laws, the Declaratory Judgment Act said you could be a person, and the 2016 law says that you need a group. See, the Declaratory Judgment Act as a person matches to the 1688, which came with my family to New Zealand on the ship. But the 2016, where you need to have a group, that matches to the United Nations 1990 human rights. They've matched that up there, and so they said it's in New Zealand. So he put, in his view, the 2016 overrides the Declaratory 1908. One means you need a group, one means you need only a person. So, and then he said, in my view, because this has never gone to the court before, So that's one point that I have to, it's that I'm fighting. I'm fighting subject with 1908 declaratory judgment. A person can do it. And then the other one is that he's got 1908 says person, but the 2016 says with the human rights, you need a group. And then he just says the 2016 stands, and so therefore you need a group. In his view, he just says, in my view. So that is only an opinion. So he didn't actually, and so that was an appeal. So then that's what I'm taking to Supreme. So what we got here is we've got subject status and laws of the 1688, which is in New Zealand legislation, together with the 1908 declaratory judgment that says we can take Prime Minister to court to question any point of law that we have a question on. We can call them into the court. And you only need one person. So there's that one. And then he's saying, no, you've got declaratory judgment, and then matched it to the Human Rights Act of 1990, which is matched to the 2016 court rules that you must have a group. So that this battle going on here between those two. So that is the human as a citizen. Oh, no. And then he comes in and says, because it's exactly what you're saying. That's in his view, that I'm beholden to the modern law, not the ancient law. And it's exactly what you're saying here, is saying, because no matter your ancient annex from your ancestors, you are a citizen. So that's what he's done. And now that I'm talking to you, I'm more clearly understanding what he has said. And it seems to me that I can understand what he said. And now I'm questioning myself whether I'm right or whether I'm wrong, which
right.
was about
the only way to solve that is to find, because you remember, if you want to go at a point of law, and you're going to have to deal with law, not evidence or opinion. You got to find the law that then allows you to define what the tests are that establishes you are subject. And once you're subject, then that moves you out from, that's a different status. So that moves you out from being a citizen. Again, those two can't commingle. You're using, as a citizen, you're using a third level of use to land as a citizen and under government, and you want to be before government as a subject. So then you got to deal with, well, there's more to deal with, but you know, you want to get to one handle.
They have the Treaty of Waitangi, and under the Treaty of Waitangi, it said that the Queen's law will govern over all the subjects and the natives. And what they've turned around and done is they rewrote a new law, and the New Zealand Maori, they kept them in their subject status, and then they removed all of us Anglo people that were given subject status at the same time as them. So the court does the criteria to go to the Supreme Court of New Zealand is that you're making a point of law in regards to the treaty. So that's where I'm coming in from here, because on the treaty, so the Treaty of Waitangi is a very important document, because this is something in Canada and America they didn't get. But here's this Treaty of Waitangi. Hang on, I'll put it up so you can see. So the criteria to go to the court of the Supreme Court is that you must use the treaty. Now, the treaty has got nothing to do with citizenship. And so that the courts have said that they recognize the treaty, but they only recognize it. See, I'll show you where they recognize it, because they only recognize it in land. And that is what I'm complaining about, because if you go and look at the treaty, I don't know if you can see here, but on this treaty,
I can see, yeah.
Right, so on this Treaty of Waitangi, what you'll see here is a preamble. And on the preamble, that it says here that Her Majesty Victoria, Queen of the United Kingdom and of Great Britain and of Ireland, and regarding her royal favour to the native chiefs and tribes of New Zealand, and anxious to protect their rights and property. That they put it both. So there's their rights and there's their property. And to secure them, the enjoyment of peace and good order, has deemed it necessary in consequence of the great number of Her Majesty's subjects who have already settled in New Zealand. So they were not nationals, they were not citizens, they were merely subjects. And so that with the rapid extension of immigration, and I come under emigration, not immigration, which is different. And we were immigrant, which is EMIGRANT, which is different from the immigrant. It's very different. And from Europe and Australia, which is still in progress to constitute and appoint the functionary to treat with the Aborigines of New Zealand for recognition of Her Majesty's sovereign authority. And then it goes on, Her Majesty therefore being desirous to establish a settled form of civil government with a view to avert the evil consequences which results from the absence of laws and institutions alike to the native population and to her subjects. All right. And then she made the Acts of Parliament, the parliamentary scrolls that gave us subject status, which was a direct covenant. It was a direct covenant with, then we were given the direct covenant . Hang on. Then we were given the direct covenant . Here that matched the treaty. Not many people got this. And then it says that certain Germans being the person particularly described in the schedule to the ordinance annexed that have recently settled, and Her Majesty has been graciously pleased to assent the removal from them the disabilities to which aliens are by law subject. So she basically removed our German nationality so that we were not aliens on that land. And then she turned around and said, all in singular, the persons described or hereto annexed shall be to all intents and purposes whatsoever deemed, this is in the Bill of Rights 1688, in the liberties to be allowed, deemed and taken to be and have been from this 14th day of June natural born subjects of Her Majesty, as if they had been respectively born in the realm of England. So we had our alien status removed. So we basically had our German nationality removed from us. And under the Treaty of Waitangi, together with the Treaty of Waitangi, which the Supreme Court recognizes. So the Supreme Court does recognize the Supreme Court recognizes as a criteria to go to the Supreme Court that the Treaty of Waitangi, but that you'll see here that the natives often use this section 2, where they only use the lands, estates, and forestries. This is talking about lands, estates, and forestries, whereas the first one is talking about rights and subjects. And
actually, rights and property. Now, property is different from land, and property is different than estates when they're speaking law. Okay, so you've got a couple of different concepts here that are all commingled here, which, I haven't read the whole entire thing to get the gist of it, but you got rights and property. Rights are to possession, not rights to ownership of land. And no one under Her Majesty even has allodium anyway. It's all under, everyone's a tenant. But there's different tenancies based on estates or property. And when we're talking property, you don't have ownership.
Yeah, that's right.
Right.
So that is absolutely correct. But that, from my understanding, when they did the 1688 Bill of Rights, it said that the Majesty would own the property, but you own the governance and you own the rights as subjects to govern yourselves and govern your country. And then they gave a list of the set of subjects' rights under God that we could use. And if they made a law that was repugnant to those rights, then we were permitted to go directly to the Supreme Court and call the Parliament in, call the government in on that question of law. And so that's what I've called them in on that question of law under my subject status. Because
but do you know what that means? Do you know what that means when you become subject? Do you know that you're changing an interest to how you convey and transfer land within your right or hold things, okay? Because again, a citizen is subject under a trust for sale, which is the Law of Property Act, 1925. The subject would be then using the warranty of the Settled Land Act, which is the land held in trust to which you have a different right. So there's a lot more to this than just, claiming I'm subject. I think that's what happens is the judge has to protect more often than enough our own selves from ourselves through our commingling. I'm not understanding the hierarchical process of what is law. And the law has already been settled. There is nothing more that the law can do, or it's not even used anymore because no one is using it, especially bar attorneys. Bar attorneys don't even know what law is. They know how to deal with those rights to property, okay? They don't know about the life estate, the fee tail, the entail. They don't deal with legal remainders. They deal under a trust. So that means in order for a trust to be established, the legal title has to be seen in the trustee, and the equitable interest have to be, given to a beneficiary. That establishes what a trust is. But a subject has a right before a trust, and that's a whole different kettle of fish. So if you want to be subject, now you don't want to hold interest through property that are granted under the government, because that's a whole different, here's actually, I think it's Littleton or Cook, which are ancient, ancient justices throughout time. I think they're around the, 1400s, 1500s, that sort of thing. And it's called remitter, and whereby if a subject is cast upon him a lesser estate, let's say a property that's held under government, okay, a lesser estate, he is automatically remitted back to his more ancient right, which is that of the subject to hold a life estate. Now, but if he chooses and he doesn't get rid of that, then that's his choice to then keep that lesser estate, and he will be judged accordingly because that's a new set of rules. So you really got to understand what rules you want to be involved in and how to navigate those rules before you may want to justify or class yourself as the subject. Because the subject is not just a, just a set of laws, but it's pertaining to things, specific things that you should know what they are in order to be comfortable in using that in that title or that legal status. And a lot of times what the judge has to do is throw us into the lesser right because we do less harm to ourselves. When you get into law, you have more, there's no wiggle room, okay? Law is steadfast, it's no gray area. Equity, to which is, that is the subject of law that is administrated over through the courts of chancery, are, how would you say, are black, it's more or less the spirit of the law, as they say. It's not black and white, it's not black and white like the common law, it is gray. So you can now, it's arbitrary, meaning that the judge can, look at the agreement, not to the letter of the law, but look at the agreement and say, well, who's acting in bad faith here? That's pretty much what they're doing. So there's more, so that's what the judge will put you in because you'll do less harm to yourself there. And it's easy for him to, now he can actually, without juries and all that kind of stuff, give a decision and a judgment or determination based on what he thinks or what he has established through his own mind and his own test of what you're saying and how he may be able to seek remedy for you, if he can seek remedy for you at all. But he's going to throw you into the group because you're equal in as much as equality within the group, that you get the same rights as they do. But if you're a subject, well, you get the same rights as any other subject, but now you're dealing with a separate interest. And that separate interest has a whole new set of rules because land is, our English law is a hierarchical system of land holding. That's all it is. So when you become subject means you have a different interest, which is a life estate. And if you're a life estate, then you come as a tenant for life, and there's the whole different set of things within that. Then you are holding both legal and equitable, and you either after death, remove in your estate what is remaining into remainders or legal remainders, or through reversion, you stop being a tenant for life and go back to a settler, and then you vest your interest that was held in a tenant for life until you have the entire possession of the legal right.
I'll just read this to you because I might be a tenant. I'm a little bit.
Everyone's a tenant for life. Everyone is a tenant for life, but
they were given this here. I'll just read this for you to see, so you'll show here. But this was upon their arrival, that the terms and conditions which German immigrants were introduced into the Kafaria, and upon which the offer is made to introduce them into New Zealand. That Kafaria were a bunch of terms and conditions when all the settler Germans, thousands of German Protestants were shipped to South Africa to build their nation, and then thousands were sent to America to build their nations. We were actually white slaves, and there were terms and conditions. The terms and conditions were set in that 1688, how we had to be treated and how we had to be governed by. That was the rules that Queen Victoria set. And there it says the German agents are to find the capital required for selecting the immigrants and forwarding them to and landing them in New Zealand. So not settling them, landing them. Such capital to be secured on the resources of the province, to be payable in 10 years, in the meantime to pay 6% interest. A board to be appointed by the province to approve the immigrants on arrival. None but approved immigrants are to be paid for. So not everyone, but all the five brothers all got paid for. The immigrants, before embarking, to sign the agreement to pay the passage money of themselves and families and interest thereon in 10 years in 3 equal payments, at the end of the 4th, 7th, and 10 years, each immigrant to receive 1 acre village lot and 20 acres of country land and an additional acre of country land for every child. £2 per acre to be paid. So it was not done real estate, it was done land. I think that land has got a different meaning to real estate. Grant not to issue until all money's paid up. So we would get a land grant from the Queen, time not to exceed 10 years. So they were given a land grant, and that's not all. They also it was called, a trust was set up called the Queen Victoria Trust, and that is what the New Zealand Maori are trying to get possession of, this Queen Victoria Trust now. And that trust belongs to all the descendants of the people that built the country. And so they were given, on that Queen Victoria Trust, they were given, you see here, that I'll just share this so you get all the information. You probably would need to, I've really caught you off guard here, but I will say to you that you've helped me immensely already just with what you've said. And I'm going to have to really think about it. But if you see on here, this one, they became the owners of the first New Zealand bank. The Union Bank of Australia established that, and the directors for the time being the board of directors, and to be recorded with the Supreme Court of New Zealand. That, when they got that naturalisation parchment paper as an act of parliament in Westminster, they had to go and swear, they had to go to the Supreme Court of New Zealand and swear the oath of allegiance to Queen Victoria. And then they became members of the shares through that land, members of a share through our birth certificate in the Supreme Court of New Zealand. And the ordinance facilitating the proceedings by and against a joint stock company. So we were placed into a joint stock company called the Union Bank of Australia. It was the Union Bank of Australia and New Zealand became the ANZ. And all the people that were annexed to this piece of paper, they'd had their alien status removed, and they were joined to the land through this trust here. I don't really quite understand it. You possibly know more than what I'm talking about here. And that was all done through the Treaty of Waitangi. This was all done pre-1870. So anyone that came after 1870 is not involved with all of this. It's only the people that were joined through the treaty and through the German settlers and Queen Victoria and all of that. So we were put into this trust called the Queen Victoria Trust as well. Not everybody's in that trust. And then the Maoris also got their own trust as well. They got a separate trust. And for them, every man, woman, and child was also given an acreage of land. And their chiefs were given acreages of land. That all went into their trust as well. I don't really quite understand it. And so the Maoris, in 1975, the American law company LexisNexis Law took over the Butterworth's Law Company in England. They took it over and they bought the rights to all of the English law. It's when they came in the 1975, they took that, they put that Treaty of Waitangi, which is a constitutional document, they put it into an act. It wasn't in an act before. They put it into an act. When they made that act, you see, when I told you the Treaty of Waitangi had the right of the subject and of the natives, when they made that Treaty of Waitangi Act, they only gave that subject right they only gave those rights to call the government to court to the Maori, and they removed it from us. And they put us into the human rights and removed us from our subject right. And then they, as you've said, what that judge has said, well, you're a citizen now, so you'll go where we tell you to go. And I'm saying, so that now I'm confused, because that's what you've made clear to me, is that he said you're a citizen, and the citizen and the subject right are not one and the same. And you cannot be a subject and be a citizen. You cannot be a citizen and be a subject. And it's quite a dilemma here. I'm confused in this place here that you've put to me.
Well, it is. I mean, if you look at any of the law articles, you know, broad stroke across the US or Canada or even New Zealand, I'm sure they always will say land law is one of the most complicated issues that we can ever discuss. And it gets convoluted the further you go down, you know, the pyramid. So I can understand the, you know, the angst and all those things, because it's quite the headspin to get ourselves between what is lawful, what is evidence, what is legal. I mean, there's just so much to it, but we're bringing it down to the simplest terms. And the simplest terms is to identify as nothing under the law, but use the law as a tool in which you want to, you know, right through, so that another party will be held to that agreement that you want to make with them. So
yes.
Now,
Their chief, their king of the time made that agreement, and we lost our nationality because they made that agreement that we would be able to use our subjects. They said this would be our law for all times to come. And now they've switched. Now they've done the Mickey Finn and switched and said, oh no, you're going to come under a different set. And that's exactly my complaint right there that you've just said.
The paradox that you're facing is that when you speak, you say, you know, they've done this to us and this is how they've progressed. The fact is, the law has moved you there, and no evidence to the contrary. You see, the law has to move. It has to move unimpeded, whereby it can't be asking everybody, you know, here's all the things you need to understand in where we're moving, because you never get anywhere, because then you know, people just maybe not care, or they couldn't understand, or they just, you know, whatever should be the case. So it is up to those who want to know what their rights are, based on the agreements that are available to them, because all there is agreement. So what are you agreeing to? Is when there's no evidence to the contrary, then they already assume that you've made a choice to be agreement as a citizen. They just said the law is moving here, and everybody goes, well, you know, here's something I can say right now that's happening at this point. Okay, right now, as you maybe heard, you know, the Fourth Industrial Revolution, WF, the One World Order, all those things, okay? And everybody's saying, well, the elite's doing that, and they're running roughshod, and they're taking over the planet. And well, you know what? They're doing it lawfully. They're playing chess, and they're giving everybody else monopoly. So they're actually fulfilling the foundational principles of the law, whereby, let's say, I believe it's a 99-year lease that Canada has, and most every other country since 1925, which will end in 2024, which means the entirety span of that system was under a trust for sale. And that trust for sale now has to end because, you know, for the very simple fact that the trust for sale has that connotation that there's an end to it. Somewhere along the line, it does have to be solved. So they're moving everyone under a trust of land, whereby all citizens will no longer have property rights, because all rights will now be in trustees. Before, citizens has rights to possess property, under the trust for sale, but now that trust for sale is closing, they got to move everyone out, which are citizens, to a new trust, which means you won't own anything. You can't, because it's no longer, at interest is no longer available, and it's all now controlled by trustees. If you look at the laws, you can see them moving from establishments of the laws that were protecting or securing the trust for sale, and you start seeing that they're moving into trusts now. They're moving into trustees being in control, and that we can solve this all by giving the trustees the full rights to do as they please without need to speak to the beneficiaries, which is, and the watered down version is the citizen. We don't need to speak to them anymore. And you can watch how that transition. So that's what they're doing. So the law is the thing that's moving here. It's everybody. It's very disheartening to know that, you know, what we've got distracted in the matrix, if you will, in the monopoly game, and we're fighting within that game, not knowing that we are actually picking up a token and we're moving around the board. We've got to drop that token. Okay, that token is just like any other game. You get up and now your life continues, and you want to be a subject, where I don't even want to be a subject, because I'm not a subject in the fact that I have more rights than a title, which would be Her Majesty, and she acts as my trustee. She's my trustee. But if I'm a subject, she is now, she has a different right as a trustee over me as a beneficiary. So
no,
I
because
only
it
have.
doesn't say that. No, because I believe that this is a mistake, because if you read that 1688 really, really carefully, what it says is that the Queen is only allowed to govern, and the government themselves, ministers, are only allowed to govern as long as they uphold the oath of all of these rights which belong to the subjects. Because when I looked at subjects in the Latin, and then you reversed it, it comes out as ject sub. And when you go and looked at it in the Latin, what it meant was to be thrown under. And then, so what it meant was, because I do English teaching, what it meant was is that in order for them to govern over us, we were thrown under Almighty God. We were thrown under these protections, and they were only permitted to govern us as long as they upheld those protections. And the minute that they did not uphold those protections, then they have to step down from their post, that the whole thing comes tumbling down. And so it got a set of rules that they had to govern us by, and they were not allowed to bring into question any of those rules. They were not permitted to allow foreigners to govern over us. Now, presently in New Zealand Parliament, we've got Eritreans, we've got our head of police is a staunch, devout Muslim, and that's illegal. They're not allowed to govern over us because their laws have got decapitation and other sorts of laws over us. So one of the laws was that they were not permitted to allow any foreigners to govern over us, meaning nothing to do with race, meaning people that were not born to our country were not permitted to govern over us. And it said that no religious leaders or any religions or any ecclesiastical leaders would have the power to have any authority of any kind over us. And so that forbids this new world order completely. It forbids it.
But it only forbids, Kate, it only forbids when a person has done his due diligence and has removed himself from being subject. This is the predominant feature. Everything just assumed and presumed because no one has done anything to prove otherwise, that they are no longer a citizen or being subject to those certain rules. I mean, no one is under English law. This is the first, let's hit that point first. No one is under English law. The only time that you're under English law, if it is witnessed through your actions that you've made an agreement, and the agreement overreaches your absolute rights. It has to, in order to give agreement value. So in order to have faith in agreement, you cannot have faith in agreement if that person stands under absolute rights, because you can never get them to fulfill anything because, hey, the agreement doesn't mean anything. I have absolute rights. So you're in agreement, and you're under the muck and mire of a few of them, you know? So until you find out what those agreements are, and that's best to come to terms with that by understanding what is law, and where you get to get to that point would be to go to read Blackstone's commentaries and then see the progression. He writes in absolute progression of your natural rights, then those of the person, and those of things. And then in each of those persons is of kings and of parliament and of, and then also of land. What interest do you have in land? Is it under directly as subject under a life estate, or is it subject to under a trust? Because remember, a trust means what? That you don't have possession of the legal title. It means you've given that legal title to a administrator, being a trustee. You're only holding equitable use. And guess what? You don't have any rights to that thing that's in trust, because that's the thing that's held there in order for you to gain asset from as a beneficiary. The only thing you have then is an equitable interest to which you have a choice of action, or choose of action, as they call it, against a trustee if he mismanages the estate that's owed to you. But you can't go after the interest that's held in trust, because that's not yours, because that's given away. They have the legal title to. You have a beneficial. So you see how this is all these layers that are here. And when you come in and you commingle, the judge has to put you into the less damaging position for what you're trying to achieve. Now, you may have made some inroads, but then you might have stepped off those, not knowing, or unwittingly stepped off. So now he's going, okay, well, now she's over here, I got to put her back in as a citizen. If you want to go, and once you get that point of law, well, it has to be a point of law, meaning you have to have those tests that prove that you have the choice in order to be a subject, and what makes that subject in order to pass those tests. You have the choice. You can be one. That's not a problem. But
I can be one or not. Can I be one if I want to?
You can be anything you want to be within the English law system as a legal status. You can be.
So I can be allegiant to the Queen if I want to?
Yes, you can. Okay.
And if you're allegiant to the Queen, because all laws in New Zealand, all of them are subordinate laws, except for the 1688 Bill of Rights, which is in the Cabinet Manual. That's not a subordinate law. And it says that all their subordinate laws have to be made in line with that 1688 Bill of Rights. And when they make laws that are repugnant, the 1688 says that and the 1908 declaratory judgment says I'm allowed to go to the court, not to prosecute, not to force them to change it. It says that I can go to the court and question them about the construction of that law.
Right, but you gotta understand what status you gotta understand what status you're asking that question.
In the laws of the citizen, right? So that's all in the laws of the citizen.
Right, but if you see, but you're coming in through the citizen as opposed to coming in through the subject. You've got to get that determined first. Your status has to be determined.
I'm trying to establish myself as a subject, but you've said to me, well, you can't, because the law. You said that the law moves, and the judge will do what's best for you.
Right.
The judge will do what's best for you for your protection, and he will put you in your citizen state, and then the law moves with the citizens. The citizen moves along whether they like it or not, because they're supposed to make. But what if they're making laws that you deem to be not good for the citizen, and then they said we're allowed to go to the court to question that?
But that's not your choice to make what laws are good for the citizen. That's up to Parliament to make that choice. See, you're coming.
No, but do they have a choice? Because it says there It says
No.
there that they're not permitted to put religious leaders in governance over us, and they're not permitted to put foreigners in governance over us. And it says that the only means for us to get a remedy from that is for the subject, which is me, to go to the court and ask for a declaration to assert that right, that is a right, that they made that law that's repugnant, and the subject can go to the court and get a declaration to view the construction of that law, and then that declaration is given to Parliament, and they can choose if they want to change it or not. They're not bound to it, but they can choose. But the Queen's position and the Parliament's position is sat on them making subordinate laws that are not repugnant to that supreme right.
But that supreme right is dependent upon your status. If you are a subject first, and then they try to pull that on you, well, of course, they can't pull it on you because you're a subject. But because you're construed to be a citizen, they can do that as long as it doesn't go against the law of the subject, because there's no subject there to challenge it, then they can do what they want with a citizen. So it's jurisdiction and it's subject matter, and it's a lot of different confusing things that you're commingling, and you're not going to be able to get to establish one point unless you get your status corrected. That's all I have to say, is that if you want to be subject, get your status corrected, and you're going to have to do that through.
But that doesn't mean that I have to renounce my citizen, does it?
Yes, because you're not, you can't be a citizen and a subject at the same time. It's
David,
different laws.
You've devastated me.
I know.
But the treaty says that the treaty says that we will be governed by the Queen's law.
Yes, but it is. It's still there.
They promised that. That's what they promised, that we would be governed by Queen's law for all times to come. That's what they promised.
Okay. Well, it's still there then.
It's exactly what you said. They're changing the will. We had that will that was left.
No, they're not changing the will. No, they're not changing the will. No, they're not changing the will. What they're doing is giving the person another option. If you come in under a trust, that means you're subject to those trust rules, to which now governs this, that governs the rights of use to property or land through, like I said, through a trust for sale that's administrated by the government. That's a whole different thing altogether. It's a whole group of people. It's not the same as a subject. A subject, if those rules were then applied to you and trying to overreach you as a subject, well, of course, then the law would come in and say, no, you can't do that. But the law doesn't recognize you yet, even though you have that right, as a subject, because they're still saying in the courtrooms that you're a citizen. So until you get that jurisdiction established, that you're a subject, then your words are moot because you haven't come through the voice of a subject yet. You have to come through a subject. You can't be citizen and subject both. You either got to be one or the other. Or what I'm doing is being completely out of English law altogether, because that's my right.
But how do I come in as a subject and not as a citizen? How do I do that?
You got to go to the civil court and file a petition. Looks like it's petitioned through your procedures to get that determination that you are validating that your choice is to be a subject.
That was my original petition. The original petition to the court was to validate my position as a subject. That was the original petition to the court.
Okay, so was that solved? Did you get an order?
No,
Did you get...
No.
There you go.
Because in order to petition to the court to get one of those declarations, you have to have been affected by some law. There had to have have been some reason. You can't just mosey on up and say, I want it. You had to have had something that affected you. And the thing that affected me is that they have created a law in the Human Rights Act that I will be bound to any international instrument whatsoever for all times to come. And the thing that had affected me is I said that I don't wish to be bound to instruments that I don't know what they are. And so I said, because that was repugnant to the supremacy law that said that no foreigners will have any power or any authority or any jurisdiction over us. I had used that. So I had asked for a declaration to establish my subject status. That's what I had asked. And the Crown Council struck me out because they said the government is a corporation, and as a corporation, the government only answers to, as a corporation must be represented by a solicitor, a learned person, a person who's worth talking to. And they said, since you are not a learned person, we will not come to the court. We don't recognize.
Okay, I get all that.
But the appeal court said they will come. And so we got back into the court, but then they hit me with fees. So then I came back in and said that under my subject status that I was trying to establish in the first court. So I was trying to get established as a subject in that first court. And I said under my subject status that all commitments and all prosecutions, because they prosecuted me back and charged me $2,700 just for petitioning for a declaration. But the other law says that they're not allowed to do that because I didn't commit any crime. I only asked for a declaration on a point of law and I didn't commit any crime. So then they hit me with the fine. So under the subject status, they're not allowed to prosecute or to charge any fees if I'm only asking for a point of law in my declaration of right. And
okay, but did you to stop?
Where he's hit me, where you've hit me, because he's come back with the citizen thing.
Right. Okay. Just I do get all of that. What has happened? The reason why that's happened because you didn't bring in the law in the first place. I know that because that's what they. Right. If they brought in the law, then they would make an error. If they said no, you can't use this law in order to ascertain your right to be a subject. If you brought in the correct law, so I would do some research and find out what that is in order to determine how to get yourself determined as a subject. You're not trying to.
No, stop. That's what I've got to do.
Yes.
That's what I've got to do. I've got to ask the Supreme Court to determine. Hang on, I think you've got something there. To determine me as a subject. And then, so can I do this, David? That I can actually, where he said you're a citizen, can I ask the Supreme Court to determine me as a subject and give me a declaration to be a subject? Can I ask that?
Well, yeah, well, that's what you need. Like, again, when we're talking about the subject citizen ordeal, maybe I should put this out on the platform here. That first of all, I'm not giving legal advice. I don't really know what it is to be a subject. What I'm dealing with is land interest as a settler, trustee, and beneficiary, the tenant for life, and using the law that I can bring into the courts to prove that I have a vested interest in a dominion right that's got to be returned to me. And I don't want to get into all that.
Oh, yeah, dominion right.
But the dominion
Ah.
right is, but the dominion right is not being a subject though. See, that's the whole thing. I don't want you to get confused with this stuff, because a dominion right has nothing to do with being subject, because that's being a subject is a tenant under Her Majesty, and a citizen is another level of a tenant under Her Majesty. It's just, 3 different levels. So what you're embarking on is that you want to be recognized as subject for whatever that reason is. And well, you did tell me, because then you can affect certain laws in order to give you certain rights. That's what you want to do. So you're going to have to determine and find out what those laws are, and what is it that then makes it determinable for the court to give you a determination that you are now a subject of Her Majesty. That's what you have to do. That's what got to be done first.
Right. Okay.
You got to get that done, and you're gonna have to keep on pounding on the door until you get it. Because every time they start talking the way they spoke to you, means you're not bringing in you're not bringing in the correct law.
That I am a subject.
Right. You need that.
Of or to.
But you better find out what that entails.
Her Majesty or to Her Majesty.
Subject of Her Majesty.
Of Her Majesty. So
I believe it is that. I mean, I know
that's what we can ask the Supreme Court to determine. We can.
But you better bring in the law. You better bring in the law and support it.
No, it's never been done before, so we don't know what the court's going to say. He'll probably say to me what you've said to me, but at least I'll have it on paper. So I'm going to ask that it's my right or choice to my docima. I have the right to swear allegiance to Her Majesty as a subject of my free will. We're going to ask the Supreme Court. I'm not going to fight that judge. I'm going to ask the Supreme Court to please make a determination that I am a subject of Her Majesty. And then I can bring in by the Treaty of Waitangi and the German Settlers Act, because there were promises made in there that we would continue to have that status. And so, I think that's helped me a lot. And then it will be up to the court to tell me why they cannot determine me as a subject. So I don't know what the answer to that would be. So I don't need to battle that I'm a citizen or a subject. I only need to ask the court if they would please determine me to be a subject. And I suppose, and then the court could determine me not to be a subject, couldn't they?
Well, what they're going to do is just going to, put you into the less harm, which would be a citizen. They're just going to keep on. Anytime they speak to as a citizen, that means you haven't brought in the correct means in which the judge can look at in order to make that determination for you to be subject. And I don't know anything about being subject. I don't know how that all works, because I never looked into it. That's not a concern of mine. So, but you've got to get that determination first, however that may look. And there's got to be, I'll guarantee there's precedents, there's law within New Zealand that has already been debated in your top courts that have defined this somewhere in there. You just got to have to keep on searching.
But what if he sees that due to the movement of law and the direction that they're moving in their laws, what if he sees that it's actually dangerous for me as a Protestant to be moved in that direction, and it's safer for me as a Protestant to be moved back into my subject direction? What is he allowed to see that?
How he maybe even come to that term, but he might not even say it that way. He's just going to automatically put you there because he knows that's for your best interest. He's supposed to protect you, but he won't. I don't think he'll put it that way.
They've changed the language of New Zealand. The language of New Zealand, first language used to be English, and they've changed the first language of New Zealand to be the Te Reo Maori language. And then the Maori king has had the Quran translated into Te Reo Maori, and they have now removed the wigs and removed the Queen's gowns from the courts, and they've put in the Maori gowns into the court and brought in customary called tikanga law into the courts, and they're saying that we're going to be governed under that. But since the Maori king, if the Maori king had never accepted the Quran in Maori language, then there wouldn't be a problem. But since he has, then as a Protestant, being ruled under Quranic rule, that's really dangerous for me. So that's dangerous because that's before the 1688, that was what we were all ruled under, all the peasants. That's why they stopped it, because they were killing us and maiming us and doing things. So it's very dangerous for Anglo people to be under those Quranic laws that have been instituted into New Zealand through the Maori king. So
well,
that's why I'm happy to have my subject status endowed upon me for my own protection, because they've made laws that are repugnant.
Listen, it's across the board, because we're getting addressed through our agreements, and agreements means that, for instance, people, with the idea of public health, this is for public health. Well, people then automatically think and conclude, well, public health means it's for each individual. No, public health means what's best for society in order to keep its economic, structure together. So if 49 people need to die out of 100, hey, that's public health. You see, we've agreed to that through our actions, and it's across the board, whether you're experiencing it there or we're experiencing in Canada. They are in essential, I don't want to use the word euthanizing, but they're not doing it. It's deceitful. They're doing it underhandedly through creating the concept of, as you know, a virus, which a virus through germ theory never existed in the first place. It's all smoke and mirrors, but you can't get people to move into a new structure of land when you start saying we're going to take all your land interest away, all your property rights away, well, people are going to bring out the pitchforks and torches. So they got to make, let's throw an act of God. Well, we'll create the germ theory and we'll create a climate change. And then they'll just say, well, it was the act of God that left us into this situation. Because our own ignorance of what law is that's why they created these illusions or these concepts in order to get the people move into the fourth level of a trust. That's what they're doing. It's just all smoke and mirror. It's all illusion. So as I'm sure everyone's getting back in the corner, they can see the writing on the wall, is you've got to get out of the system, and the law allows you to do that. Okay, there is law that allows you. The law has been actually perfected to make sure that all your interests, all your rights are intact. But nobody uses the law because they're citizens, or even to a greater degree, a subject. But you're before even that. You're before all titles, because man before titles. If we use the syllogism, God created man, therefore man can't be greater than God. And then man created corporations, therefore corporations can't be greater than man. Well, that's simple. That's logic. So why are we now under the underbelly of corporations? It's because our agreements have now landed us there through our actions. And that's what law is, rules over actions, or rules of actions. So we've got to stop doing what we're doing, but we're not going to get there by commingling, because the judge is only going to listen to what he can listen to. And if you don't bring in the law pertinent to that subject matter, he is not going to be able to give you the right order that you are asking for, because you're not speaking to the correct subject matter yet. So if you hear them speaking about, you're a citizen, you can't do this, well then hold it. Hey, my fault. There's something here that I'm not speaking to. So you've got to get in the law. Then if the judge overpowers and you brought in the law and he has to go through tests, then it's appealable, because that's he can't run roughshod over you without giving you the right, how am I going to say, what's that word again? The access to the law, let's just say, which means that he can't block you from using the law if you use the law in the first place, to which now becomes an appealable offense, whereby the judges will look at what the judge erred. If you did bring in the law and then he didn't recognize it, then he'll err. So you got to have the law, And if the judge at the Supreme Court level does not, he doesn't respect the law, or he overreaches the law, well, then now you've got an appealable offense you can bring to the Court of Appeals and say, hey, here's what the judge did. And the appeal court will recognize right away whether the judge created an error or not in law. So everything's actually for your benefit. We're just not using it generally in the right way. So the procedure has to be allowed to you, if to everyone equally, that allows you to bring in a point of law and have that order or that determination made. And if you did bring in the right law and the judge did not give you the right order, well, then you have an appeal that you can bring, and it'll just be on a point of law at that point, and it's done. And it will be said, yeah, he made an error. So again, the simplest thing, instead of bringing all of these other connections together, is just find the law that gives you the credibility or the determination to be a subject. And you cannot be a subject and a citizen at the same time, because you just know a citizen's not your best interest right now. It's the lowest form. Yeah, you don't want to be one. So you got to get out of that. You got to get out of that assumption.
They're not acting, because that's exactly what I'm saying. They're not acting in my best interests.
No, they're not, because you're a citizen.
They're acting in the best interests of the native Maori only, and they're not acting in the interests of any of my people. And the agreement, the treaty was that the agreement of the treaty that was that we would be together and that there would be no division. And I do have the law where in actual fact, George Grey, a group of Anglo people in 1831, they went into the court they said that there were two sets of government in New Zealand, and there were groups in Auckland who wanted to govern. They were the Jehovah's Witnesses and the Catholics that were running their own government according to their religious laws, and any money, they were taking government money and giving it to their own organisations. And then the other people were not able to oversee how they were spending that money. So they made a petition to separate the South Island from the North Island. And they said that we want to be protected under the subjects' laws. We wanted to be subjects of Her Majesty. And we want to separate ourselves from them. Let them have their laws, whatever they're going to do. We want to be subjects under Her Majesty. And what the George Grey said is, no, I will not let you be separated into those two separate laws, because that would cause disharmony between you. But he said, what we do need to do is this is coming back to what you're saying. We need to centralize everything into the central government, and the central government would make laws that apply to all of you. But that comes under the 1688, because they're not allowed to rule by division. But currently, the New Zealand government has said we're going to divide the government into 50%. And 50% of all revenue is going to go to New Zealand Maori, and they can do what they like with it. And the other 50% is not permitted to oversee what they're doing with that money. But there's only 200,000 of them taking 50% of the economy. And then the other 50% that they want to have is going to be the Anglo people that number in 3 million. And they're going to take all their taxes and all their money and give it to this smaller percentage, of which they are all individual private companies, and the white 50% is not allowed to oversee. So that's why I'm saying that they're governing, and under the 1688, that's called ruling by division, and it's illegal. And so I'm saying that as a citizen, they're not making laws that are, and so that was done by George Grey. George Grey said, no, you all go into this one pot, then everybody gets the same, and no specific group is going to be in control of finances of New Zealand, so that when they make a health law, right, that health law should apply to all of the New Zealand people that are born to New Zealand, not a health law that is only for Maori people, where they get a percentage of the money into only them because they want 50%. So that was the fight.
And they can do what they want to do until somebody argues a point about that specific issue. But again, they're not dividing anything because they are saying we're government and we have citizens. So if you were as a subject, obviously they couldn't divide or could give those rights if everybody was a subject, because then again, those rules of 16.8 would apply. So you're just, what we're doing here is, you can see you're moving into citizens and seeing what's happening to citizens. And that's a whole, it's like everybody working for, I don't know, you guys got a Walmart there, or do you have Walmarts there? Okay. Well,
we're Woolworths.
Okay, so Woolworths. So everyone's working for Woolworths, and everybody's, upset about some of the policy that Woolworths is doing. But, if your collective cannot fight that issue what Woolworths doing, then it's going to stand as it is. But guess what? When you're not working for Woolworths and you're not doing Woolworths anymore, well, you're not subject to the rules. So what's happening here is everyone's become subject to these rules because they're agreeing through the possessions that they have. They possessed property that they own right now that gives them obligation under the government to take care of that property as a citizen, as a right to use that. They have an obligation. As a subject, you have a whole different obligation. And then those rules you just said applied. There is no division. There is no way that they can, place rights in one group of subjects and take away from another group, because now that's a whole different group. That's a whole different party. That's a whole different set of laws. It's not Walmart or Woolworths anymore. It's now outside of Woolworths. It's different. So we really got to understand what the subject matter is. Government has a different subject matter than what the Queen immediately is under her. She has a different subject matter. And as soon as you get into a trust, that means that you have an equitable interest, and you never have the legal interest that's held by or directly under the Queen. You don't have rights to that. You don't have a right to say to that, or nor does the government have a right to say anything against it either. Or can they repeal any of those laws that the subject has? They can't do that because it's not their laws, but they can create as many laws as they want for their own. So all they're doing is beginning to create rules that they have the right to do, because they've, had ever how long in New Zealand to govern. They've got their own government, sovereign power, and now they're creating rules for citizens. And those rules apply to the extent of how government wants to operate, by long as they're not going against the law. Well, they're not going against the law because nobody's in the law. They're doing a lot of wrong. There's a lot of deceit. There's a lot of greed. Yes, all of that. I'm not saying that that's not wrong. Let's face it, they've gone crazy. Okay, I'll say that. But as according to the strict letter of the law, are they doing anything that is violation of the law? Well, not that anyone's brought forward they are, because no one's in law anymore. They're all in equity. So we got to get our heads into, understanding what is law and how do we make agreements, because those agreements are an obligation. Possession creates an obligation. You have no possessions under the government. Guess what? There is no obligation. But if you have, then you have to look to being a subject. What interests can you hold as a subject? It's different, again, than what it is as a citizen. You can't be both. So that's where we're at. I just noticed at the time, I'm really getting, I'm going to 11 o'clock.
Yeah, you must be getting tired now. But boy, you've really helped me a lot.
I'm glad that I'm able to, but I'm not, there's another level that you're not even yet to express, but once you get into understanding what law is, you understand, holy mackerel, I'm actually the one with all the power. But you have to get there and understand what law is to find out how come you got all the power, yet you're giving it away through, subsequent agreements that you're not familiar with. So,
well, I think what I'm going to do is, because I know you're tired, it must be very late over there. I'm just going to say, I'm just ever so grateful to you, and you've given me a lot of food for thought, and you've kind of smashed me a bit out of the park, to be honest. So now I'm not feeling confident at all, but I'm understanding what you're saying, and all the things that you're saying are the things that I'm going to face. And if I can't get my head around what you're saying to me, but what I think I'm just going to do is I'm just going to ask the Supreme Court to determine my status as a subject, and I will ask the Supreme Court that if I can't, maybe I can just ask them to explain it to me. But I think I will just ask the Supreme Court to determine me as a subject. And
but you have to come in a whole different, you have to come in a whole different petition.
I don't feel that they're working in my best interest, so I have to accept that I'm a citizen. But I'll say that I don't view them as working in my best interest, and I would like a declaration to determine my subject status, and I will give them the reasons why that I'm afraid and what I'm upset. And then what I think I'll do is I'll just leave that with the court, and I won't look at winning or losing, but I'll just let the court know that as a citizen, this is what's on my mind, and see what the court says.
Well,
and
like I said, can I just interject there? For whatever reason you go into court now, you can't go now and change the issue of get that determination. You have to bring in a different petition. It has to be, it's a different issue that you want to bring in. So what you're going to court for, I'm not really 100% familiar with. I can get some of the gist, but you're not going to be able to deal with that issue in the court because you didn't bring that through the court through your petition in the first place. You have to make sure that you bring in the correct subject matter that you want to deal with in each issue, because again, they can't hear you. You got to be succinct and directive of what you want to deal with. And so that means a new petition has to be filed to get that determination. Okay.
Yeah,
you're not going to be able to get it in this court. You're not going to be able to, because it's not what you're there for. You're not asking for that at this court.
Well, the appeal has to be in 4 days. So I've got to put something in because I've already said I'm going to appeal it about the fees. So I'll just, now that you're saying to me what you're saying to me, I've got a hugely better understanding of what's going on, even though I don't understand everything. I think I've got to put the appeal in. So I think I'll just, struggle through there in the dark and see if any shit sticks. That's what
well, that's pretty much what you're going to have to do. And that's a lot what I've always done before.
But going by what you've said to me, I really didn't understand what that judge meant by calling me a citizen. And I understand what he meant by that now.
Yeah.
And so that gives me, so even if they just send back to me and say, we don't accept your appeal to the Supreme, even if they do, I'll have a really good understanding why. And that's going to save me a lot of time because of what you've just told me today. So I can accept that. Or if they say, we do accept you to come into the Supreme Court, it probably isn't going to mean that I'm going to win, but it's probably just going to mean, well, we're going to listen to you as a person. So that's all it's going to mean. And so either way, because of our conversation today, it's going to come up. It's going to come up sitting well with me either way, whatever they say.
Yeah, good. Yeah.
I understand now, and I didn't understand before. I just want to say thank you very much for that, Mr.
Well, you're
David.
welcome, and always have fun because it's all about learning. It's you can't make any mistakes. You can only find ways of improvement and come in differently. But that's what you'll need to do: petition, get your status determined, and now you've got all the power. See, now you've got the rights. You got to have the right first before you exercise the power. You can't exercise the power when you don't have a right. So you've got to have that. You got to have the right first. And once you got the right, now you can say all those things because now you have the right, the power to say it. So
all right.
I'm
One more
rock and
note.
rolling.
All right, you're rock and rolling. Oh, but wait, because I've got that last bit. Okay, can you just say that that last bit, because I really need that.
Well, I'm saying
so we don't have the right.
You have to have the right first, Kate. You have to have the right first.
Yeah. You have to have the right. Yes, well, that's right. So
That's
you
right.
have to have
Yeah.
the right first. You have to have the right first in order to use the power of that right. Is that what you're saying?
Exactly.
You know,
you can't stand at the podium with the prime minister and without that right first. So you have to have it in order to exercise it.
The power.
So you got to have the power, girl.
That right. Yes. So that's perfect what you gave me. Yeah, I won't explain to you why that's so perfect, but it does come down to my first case, because I had actually asked for a declaration to give me that power. That's what I had asked. So that's what I can still bring that back to the Supreme Court. I can still tie that in very well. We'll just see what sticks, David Higgs. But boy, you gave me some wicked information here. You're a god to me. You're just really
well, geez, well, thank you. I don't want to go that high, but I mean,
no, you're amazing.
I just do whatever I can help out.
Thank you. See you later. Have a good sleep.
Okay. Thank you.
Bye-bye.
Bye now.
I'm going to end that. Stop recording.